Okay. All right, everybody. Welcome to week 8. So, this is sort of the official last session. Week 9 is just going to be a very short session, just some question and answers. It'll be with Rachel H next week. Unfortunately, I will not be there. So, week 8, settling your case and learning about alternative dispute resolution. So tonight's guest speaker is Kahe Ze. And I'm your moderator, Jennifer B. And all right, let's get started here. So again, we just want to do the territorial land acknowledgement. So we would like to acknowledge that we are on the traditional, ancestral, and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh nations. So again, just a weekly reminder about AC Friends of Court. So we are a nonprofit organization that began in 2011. The first legal forms workshop was held at the Access Justice Center located at 800 Hornby Street at Robson Square. Our legal forms workshops helps British Columbians access affordable legal help for a variety of areas of law. Approximately at present, we have 45% of our clients are family law clients. AC Family Law School is the first program of its kind in BC. And again, we would like to acknowledge all the contributors for AC Family Law School. So it's Kylene Wong, Don Batista, Dana Cornwell, and Andrew Pillier. So again, just a reminder about legal advice versus legal information. AC Family Law School does not give legal advice. We give legal information only. So again, legal advice is answering questions that are specifically related to your case. So when you ask questions directly about your case, that is legal advice. Legal information is providing answers to questions or giving or for asking for general information that is not directly linked or specific to your case. So asking what court form do you use to start a provincial court case? So that is legal information. So again, some housekeeping reminders. All sessions are recorded and will be emailed to registrants at the end of this course. We remind everyone that recordings and reference materials are not to be redistributed, and so we thank you everyone for your cooperation. Please make sure your mic is muted and your video is turned off. Please put your questions in the chat box. So again, all questions are going to come directly to me. Keep details of your case private. So again, if you're asking questions, try not to ask about your specific case. And any questions or concerns that you have, any questions from previous sessions, any questions tonight that don't get answered, please send it to info@litigantschoolbc.com. So anytime you have questions about AC Family Law School, please send it to info@litigantschoolbc.com. Try not to send anything to AC Friends of Court at their email address, which is different from us. All right. And so please respect the speakers, AC volunteers, and staff and other registrants. Reminder that any kind of abusive or harassing language or behavior will not be tolerated. We reserve the right to remove any individual who engages in behavior that the course facilitators determine to be disruptive, abusive, or harassing. So about our guest speaker tonight, so Kahe is an associate lawyer at Broadhurst Coy Family Law. She obtained her Hong Kong LLB and BC Juris Doctorate law degree in 2023. She has worked with Rise Women's Legal Center, providing family law services to women and gender diverse people across BC. Kahe works to provide tailored solutions based on her clients' needs, and preferences. She has represented clients in both provincial and Supreme Court. So tonight's objectives and outlines, it's just to go over the different ways that one can do settlement, so alternative dispute resolution. So we have mediation, arbitration, four-way meetings, collaborative family law, family justice counselors, parenting coordinators, settling your case. So whether it's by a consent order, a final order, separation agreements, or minutes of settlement. And then we'll have a question and answer period. All right, so I'm going to stop sharing my screen and let Kahe take over.
Perfect. Thank you so much, Jennifer, for the introduction. So I'm just going to start sharing my screen. Just give me a second. Okay. Can everyone see my slides?
Yep, see your screen.
Okay. Perfect. Okay. So tonight we're talking about, alternative dispute resolution, which essentially means resolving things out of court. So you're looking at a slide where a typical litigation matter would be you start a claim, you go to a family management conference, you do whatever applications you need to, you go to a family settlement conference, and finally trial. Of course, this is an oversimplification of the process, but this is typically what happens. So you can actually settle at any point in your litigation. So it could be right after you start a claim, it could be after your applications, it could be at the settlement conference, or even during trial. So according to Settlement Smarts, which is and a resource I will talk about a little more later, more than 95% of cases settle before trial. So a very, very minority of cases go to trial. So the rules also kind of encourage settlement before trial. You can see that in the provincial court family rules, it says parties may come to an agreement or otherwise reach resolution about a family law issue at any time. So the court want you to settle outside of court. So once again, I plug in the Family Law Act. The purposes of this part are to ensure that parties to a family law dispute are informed of the various methods available to resolve the disputes, which is what we're doing tonight. We're going to go through some of the methods we can to go to get a resolution. It's to encourage parties to resolve disputes through an agreement before making an application to court. So they also encourage parents and guardians to resolve conflict other than through court intervention and create parenting arrangements that are in the best interest of the child. So the rules do encourage you to try and settle outside of court and to not, go to trial. So, okay, why should we settle out of court? So I'm just going to briefly kind of talk about what are some typical benefits to resolving out of court. So usually out of court resolution is faster than litigation. As I mentioned, you can do it at any stage. Depending on the method, it could be cheaper. So for example, if you decide to retain a lawyer for trial, it would most likely cost a lot more than if you also retain a lawyer for mediation. But of course, it'll depend on the method, which we will kind of go through later. So the second thing is that it's voluntary. So alternative dispute resolution processes, so we call them ADR processes, are voluntary. So the idea is that both parties have an understanding of what to expect before they agree to engage in these processes. So the idea is that it'll be easier to come to a resolution. So for example, if you and the other party go to mediation and you understand that the goal is to come to a resolution, then it typically is easier to come to an agreement. The third thing is communication. So family law matters are highly personal, and as I'm sure all of you know, and it sometimes involves children. So trying to settle things amicably outside of court could encourage healthy communication between parties, especially co-parents who have to work together for a long time. So one of the main benefits I would say is control. So if you go through an alternative dispute resolution, you will have way more control over the process and the outcome than if you go to court. So when you go to a court, you'll always be uncertain of a decision from a third-party judge. Later, we will discuss this in more detail, but for example, you can decide on the scope of topics you want to be dealt with at mediation or arbitration, or the kind of process or what the arbitrator should consider. We'll talk about those a little later. And you can also come to deals that a court would not be likely to award. So we have, for example, clients who think that their property will increase in value, so they don't want to sell it yet, but no one can buy each other out. if you settle out of court, you can agree to, let's hold the property together and then we'll sell when we want to later when it increases in value. But if you go to court, more than likely a judge would say, split 50-50, sell it now. So, you can come to deals that a court might not award you. So another thing is that privacy. So ADR processes are confidential. So if you have been to a provincial court, you might know that a lot of times in court, it's an open courtroom or decisions will be reported so other people can see those. There's a lot of issues regarding privacy if you don't want other people to be involved or to see what's going on. And finally, it's a lot more flexible than court. So it goes into the issue of control as well. So the timing, what options you have, all of those are way more in your control compared to when you go to court, when it's all decided by a third-party adjudicator. Okay, so just to kind of give you guys a brief overview of what we're going to talk about today, I sort of structured my presentation as, how you can settle out of court. These are some methods of which you can employ to come to a resolution. So there's negotiation, so, talking to the other party. Mediation, which is negotiation facilitated by a third-party mediator. Collaborative family law, which is when both parties agree to not go to court and hire lawyers. This one is a little bit unique, so I'll talk about it later. So four-way meetings are sort of meetings between parties facilitated by lawyers or other third parties. And arbitration, that is when you hire a private adjudicator to make a decision. So I'll also go through who can help. So what are some resources out there? So there are family justice counselors who are with the government. There are parenting coordinators that are mostly private personnel that you can hire. And then finally, I'm going to talk about, okay, so after you settle, what do you do? How do you put your settlement into an agreement? And typically it will be by consent orders that could be final or interim or separation agreements. So this is sort of how I structured today's presentation. If you have any questions, message Jennifer. So one of the things that I wanted to talk about up front is that the processes I talk about today might not be for everyone. Today, we're sort of going through the options available. An example would be when family violence is involved, mediation might not be the best option. Another thing to consider is costs. There are a lot of good and free and low cost options out there, and some of those we will talk about today. But if it's not feasible for you, that's totally okay. And I wanted to be clear that, there's no one method of resolution that is better than the others. So today we're going to go through what options are out there so you can make an informed decision of what works best for your family. So first we'll get into negotiation. So this is the basic, talking to the other party directly. There's a really good resource prepared by the National Self-Represented Litigants Project called Settlement Smarts. So today's discussion a lot will be rooted in negotiation. So negotiation can be between you directly or with the assistance of a third party. Sometimes it's a lawyer. Sometimes it could be your mother-in-law or your sibling. Family members can help with that as well. So I really encourage everyone to check out the Settlement Smarts pamphlet. It is a really helpful guide, and it sets out a lot of negotiation strategies and things to be aware of. So I'm going to briefly go over some points that I think really set the tone for today's presentation. So number one, considering settlement is not a sign of weakness. If you watch courtroom dramas, they always talk about winning cases or losing cases. But when it comes to a family law matter, we should be forward-looking and see how to best resolve issues in a way that everyone can live with. And so, the goal is to move on. And settlement is not a sign of weakness, but an indication that you want to resolve the issues and come to an agreement. It is not winning or losing. It's about what is best for everyone and sort of how we can move forward with our lives. Which brings us to the next point, keep your eye on the prize resolution. Family law matters are by nature very emotionally charged, and it's really okay to feel things. It's okay to be angry, sad, stressed, all of those things. But it's really important that you reassess your position constantly. Solomon Smarts has a really good line that I'm sort of going to just plug it in right here. In a legal dispute, no one party is ever going to get everything they want. Even if your case goes all the way to trial, there's no guarantee that you will win. So focus on getting a resolution and moving on. So it's very important to keep that mindset in the forefront and to keep your eye on the prize. So number 3, we have choose your battles. I think this one is pretty self-explanatory. Think about what a result you can live with, what are things you think that there's no wiggle room, and what are things that you can compromise on. So it's to reassess your values and all of that stuff. So number 4, continually assess the possibility of settlement. It's important to keep an open mind. Even when you're approaching trial or at trial, you can still settle. So it's always good to think about whether there's a possibility of settlement while your matter progresses. Number 5 is to be pragmatic. So the guide sort of puts it quite bluntly. It's when you should be ideal and when you should be practical. So settlement sometimes comes at a risk-benefit analysis, right? What will you get in court versus what you will get if you settle? So it's very important to be pragmatic and grounded when you sort of think about what resolutions you can have. So number 6 is to take your time. Don't be pressured or rushed when you look at proposals from the other side, or don't be pressured to settle when you're not sure of the facts or when you're not sure if your rights are being protected. So this is just as important as prioritizing settlement, because you don't want to come back and be upset that you made a decision when you're emotional or when you feel pressured or rushed, right? So number 7 is to stay open to opposing counsel. So sometimes, your opposing party might have a lawyer, but it's still important to stay open to them. It's important to keep in mind that they're not the enemy and they actually have a duty to treat you fairly. And in fact, sometimes they could be really helpful in discussions because it's good to have a third party sort of in between you and the opposing party. So it is very important to keep an open mind and sort of not see them as the enemy and say no to everything they say. And number 8 is to insist on being in the loop at every step. So the comment the guide sort of has is that, some self-represented litigants have reported that they think they're excluded from conversations about settlement between the lawyer on the other side and the judge. So this might happen, at, your family settlement conference or family management conference. This situation is very disempowering and you don't have to accept this. You should always make sure that you're in charge and included in settlement discussions. So these are some tips from Settlement Smarts that I think are really, really good, and I think everyone should go read this guide. So, okay, 6 tips from Settlement Smarts. These are some practical tips on what to do. Make a list of what you want and why. You should prioritize your list and see what you can live with and what you cannot. Identify what you can be more flexible on. Brainstorm alternatives to your essential items. Get another opinion as a reality check. So when it says get another opinion, it could be, talk to a friend, talk to a neighbor, bounce ideas off of them and see, what is reasonable and what is not. And they might give you another perspective on your ideas. And also assess what may happen if you don't reach an agreement, which is sort of what I said about the risk-benefit analysis about when you go to trial, what's going to happen, right? Okay. So when we talk about informal negotiations, what do you do? So a lot of negotiations start with drafting and submitting a proposal, which is what we also call an offer. So you might have point form offers like, child support, you want this, you want that, spousal support, this and that, property division, whatever the terms you propose are. And another way you can do it is to just arrange a meeting with the other lawyer or party. Obviously, when you do these things, you should mark if it's written or verbal, you should always make it clear that it's without prejudice. So without prejudice means that it can't be referenced in court at a later date to be used against you. So you would use without prejudice to signify that, oh, these are for discussion purposes, this is for settlement purposes. So document all discussions. If it's in writing, that's great, save them somewhere. If it's not in writing and it's verbal, remember to take notes and, have a recollection or a journal of what's going on. It's when offers go back and forth, it's very easy to lose track of what has been discussed. So it's really important to document all discussions. And then you should be prepared for counteroffer. So when you make an offer or you make a proposal, it is very unlikely that the other person will accept all of it in its entirety without any changes. So it's always good to keep in mind that it's very likely that they'll give you a counteroffer, and you should consider what you are willing to accept or what you're not willing to accept. Okay, so now we go into mediation, which is sort of a facilitated kind of negotiation. So we will get into the slides. So mediation is a voluntary process. It's negotiation facilitated by a third-party mediator. So there are a couple of mediation styles. Conference mediation is when everyone sits in a room around a table and discuss ideas. So usually happens when the parties are in a relatively, amicable and civil relationship, and everyone is okay with sitting around with each other. So shuttle mediation is when your third-party mediator walks between two rooms. So the parties are separate and in two rooms, and then the mediator will walk between the rooms to sort of bounce ideas or talk to each party separately and convey messages in between them. So this can be done virtually or in person. So it could be a Zoom mediation like we're doing now, or it could be an in-person mediation at someone's office. It could work either way. So typically what happens if you're successful, you'll enter into a written agreement. And that is what we will talk about later, as in how we record our settlements. And as I'm sure you guys have already heard, it is very important, or it is ideal, to get independent legal advice at the end when you get an agreement, because it's always good to have a lawyer look over your agreement. If you don't, then you should still take some time to go over it clause by clause. It's when you negotiate a settlement, it's very important to be mindful of all the terms, because sometimes you might be thinking about specific terms, but then you don't remember to go review the other ones. So it's always good to have, another person look at it and see if it's all good to go. Okay, so let's talk about mediators. So a mediator is a person specially trained to help people resolve conflict. So not everyone can be a mediator. So some mediators are lawyers, but some of them are not. So there are mediators out there that are, social workers or psychologists. And the mediator is a neutral third party who cannot give legal advice to either person. So they are not biased, and they shouldn't be biased either. So private mediators out there typically charge by the hour. So a lot of them charge like lawyers. So here are some resources where you can find, mediators, or sort of where you can get free mediation services. So first of all, Mediate BC, they have a list of all qualified mediators. So the link is right here if you are interested. And they do have a very interesting free online clinic called Ask a Mediator. So it happens every first and third Tuesday of the month between 4 to 6 p.m. And what it is that they will have a mediator who's on the roster, who's qualified to have an open Zoom meeting that you can log into, and you can ask questions to them. So anything related to mediation, they can't give legal advice, but they can answer some questions if you have any about the mediation process. They can give recommendations and all of that kind of thing. So it's a very good online resource that you should check out if that's something you're interested in. So then there's also the Access Pro Bono virtual family mediation program. So this is a free online family mediations and advice services. So what they do is they match you with a lawyer who will give you independent legal advice before and after mediation. So all of this is free. It is a really good resource, and they have a great pamphlet that's really clear on their requirements and how to enroll. So I have attached the link here, and I strongly recommend you guys to go check it out if that's something you're interested as well. So as Jennifer mentioned in the introduction, I worked for Rise for a little bit, so I am a little bit biased towards them. I think they are a great service, and they provide limited legal services to women and gender diverse people, and specifically only in family law matters. So they can provide summary advice, legal navigation. They have advocates if you need them, and if you have an agreement, it is very likely that you can give it to them and they can look it over, give you some advice, or at least triage and see how they can help you. They're a great resource and strongly recommend. So finally, we have Everyone Legal Clinic. So they are fixed fee services. So usually lawyers bill by the hour, but Everyone Legal Clinic gives you an upfront charge. So they'll tell you how much they charge for the service, and then they can help with a wide range of legal issues. So they don't only do family law, they do civil, they do residential tenancy stuff, and they can help with legal issues, including uncontested separation and divorce, property division, financial issues, and domestic contracts. So if you go onto their website, they have a list of all their services and how much they cost. They are typically, they don't have an income requirement. So if you have any concerns, or if it's a simple separation matter, they are also a great resource to reach out to. Okay, so we're getting into arbitration. Arbitration is different from court, even though I put the gavel here. Let's go to the slides. Okay, so arbitration is when you get a private adjudicator to make a binding decision. So what that means is you and the other party will get a third party who's qualified to make decisions to essentially act as a judge for you. So any decision must still be consistent with the Family Law or Divorce Act. So they can't make decisions that are outside what a court would order. So they still have to be consistent with the law. So it is an adversarial process where you would have to make submissions, the other party makes submissions, and then there will be a decision at the end. So kind of like court, but the difference is we will sort of go through the differences later, but the idea is sort of like court. So your arbitrator has discretion to establish procedures for conduct, make an interim arbitration award, and make a cost award. So when I say procedures, I mean, for example, in provincial court, you typically give evidence by verbal, so oral evidence. So an arbitrator might, if you prefer, it might be something that's written. So you would swear affidavit, which is your written testimony, instead of giving oral evidence. So some people prefer having everything in writing instead of being asked questions. And then when they might be able to make an interim award, which means they can have a decision before they resolve the entire family matter. So for example, if you have an urgent matter for parenting issues, they could make the interim award before you have a final arbitration award. So they can also make a cost award, which is cost means legal costs. So usually when someone we call it substantially successful. So they have a strong claim. They got most of the things they asked for. The arbitrator can make a cost award. So a decision must be given in writing. These are set out in the rules. And if you want to appeal it, you would have to go to the BC Supreme Court. So that cannot be done in the provincial court. So we won't go through the procedures of appeal today, but it's something that everyone should know. Okay, so why would you use arbitration over court if it's so similar, right? So obviously, one of the pros is that it's voluntary. So it's always better to go into a process where you have a lot of control over and you can pick who your arbitrator is. You can pick when to do it. You can pick how you do it. And, control and flexibility is something we talked about. So you can decide on what process, what issues. You can also decide on, what arbitrator you think is most qualified. So when you go to court, the judge is not up to you to decide, right? And another thing is that it's private and confidential, same as when we first started talking about this. The decisions will be, even though it's a written decision, it won't be reported. So it will be private and other people can't see. So typically it would be faster than court because it's always easier to book a private arbitration than it is to schedule a court date. So typically it would be faster than if you go to court. So it can be really efficient because you can streamline the process. For example, you can decide on dates when you exchange documents, exchange disclosure, exchange submissions, and all of that. So it typically is more efficient than court. So finally, it can be combined with mediation. So it's something we call medarb. So some mediators or some arbitrators they can do both. So they have the qualifications for both. And then you can go to mediation first. And if you don't settle at mediation, you'll go to arbitration. So the same mediator will then become your arbitrator. So sometimes it is when people think that we might not settle at mediation, but we still want to try, then they might decide that, okay, let's try medarb so that we will have a resolution no matter what. So the cons are obviously costs because you would have to pay a private arbitrator. So in court, you don't need to pay it for a judge's time, but an arbitrator, you would have to do that. And the appeal is quite limited, even though I say that you can appeal at the BC Supreme Court, you'll still have to establish the same things that you would if you appeal a real judgment. So it is not as easily overturned as a lot of people think. So I have listed some resources where you can find arbitrators. So the ADR Institute of BC has a list of arbitrators that can help. It's kind of like a roster, like the one I showed you just now for mediation. Arbitrators are required to have specific experiences in family law. So it is quite difficult to become an arbitrator. So all of them are really experienced and they do have to have family law experience specifically to arbitrate on family law issues. So there are a couple of types of arbitrators. So if they are a lawyer, they can make decisions on all family law issues. So everything, spousal support, property division, child support, income, all of that stuff. But if your arbitrator is a psychologist or social worker, they can only decide child-related issues or straightforward child support. So when they say straightforward, there are a couple of requirements under the rules. One of them being no party's income is above 150K, and there's no specific complications over the party's incomes. So there are limitations on what they can decide depending on their experience. So it is something to be, to take note of. Okay, so we are getting into collaborative family law. This is, I understand that this is not for everyone. It's typically for people with legal representation, but I still think it is good to go through and to understand that this is an option that's out there. So the collaborative family law process is a voluntary negotiation process designed to reach a consensus outside the court system. So both parties will retain a lawyer and they will sign a participation agreement. So what happens is the participation agreement sets out that you will not go to court. If settlement cannot be reached in this process, each party must retain new counsel. So their original lawyers are conflicted out. So you can't have the same person as your collaborative lawyer and your litigation lawyer. So the idea of collaborative family law is that it's a team-based approach. So they may involve multiple professionals. So I will talk more about divorce coaches and financial specialists, child specialists. So the idea is that everyone requires support, and you'll both have lawyers so that you have the legal support you need, and then we promise not to go to court. So that's the idea of it. So it's a confidential process. All your communication is sort of automatically without prejudice. So collaborative family law only works if both spouses commit to engaging honestly and respectfully, and they commit to complete and open information disclosure, because there's no court involved. So it only works if everyone is honest and open. So four-way meetings are also mainly for parties with lawyers. It happens a lot in collaborative family law settings. So both parties will have meetings with essentially the four people will meet together. And then it's a good way to bounce ideas off of each other, because you have two lawyers representing two people, and then they will discuss with each other what are the best next steps, and everyone will be involved and engaged. So this is typically a way that's used by people with lawyers. It might not be for you, and that's okay. And we will move on to divorce coaches. So as I mentioned before, in a team-based approach, so you don't have to hire divorce coaches in the collaborative family law process. You can hire them whenever you want. So these are certified professionals trained in fields like psychology, counseling, or social work, and with a specialized training in divorce. So they're not exactly counselors, but they can provide emotional support. So what they are is they teach you how to navigate the divorce process. They can help you with communicating with your ex-spouse. If you have a child, they can help with co-parenting. So, how to communicate with each other, how to set ground rules, and all of that stuff. So goal setting as well is to sort of have an end goal for all of this. And divorce coaches are really good resources that can help sort of be a more holistic support on what to do in your divorce. So again, you don't have to engage these people in the collaborative family law process, but these are some personnel out there that can be helpful if you guys think that it's good for you. So here's a link. They have a roster of divorce coaches, and they have more information on who these people are and what they do. So a financial specialist is a neutral expert that can help educate you about the financial side of your divorce settlement. They can essentially is an advisor for your finances. So they can empower you to make sound financial decisions, help you plan for your financial future, and facilitate fair agreements between you and your spouse. So their role is to gather and organize financial data, assess each person's financial understanding, and provide necessary education. So for example, maybe one party has more knowledge on investments, so a financial specialist can help balance that, and so that no one is at a disadvantage. So they can help identify financial issues specific to your case. So for example, pensions or something more complicated that needs to be addressed by someone who has special knowledge, determining your financial objectives. So they might speak to you and say, okay, well, what are your goals? What are you hoping to get out of this divorce? And they can help set some financial objectives in the separation. So then they can also manage financial expectations. So they act as an advisory role and see, what you can expect and what you shouldn't expect, frankly. And they can assist in evaluating settlement options. So what's fair, what's not, what is a good way to split the assets, and all of that stuff. So we then have a child specialist. So this is for people with children, obviously, and they are professionals trained in collaborative family law who act as a neutral advocate for the children's interests during divorce proceedings. So even though I say here that they are trained in collaborative family law, you don't have to engage them only when you're in a collaborative family law process. So you can go get a child specialist even if you don't sign a participation agreement. So their role is to advocate for the children, provide a safe space for the children to chat. They are here to guide parents and develop parenting plans. They are supposed to maintain neutrality, so they shouldn't be biased towards any parent. And they also provide limited therapy for the children. But typically, if the children need therapy, they would go to another expert or another counselor. So here are some specialists that are involved in the process of collaborative family law or otherwise, and they are here to help guide you other than the legal aspect of family law separations. Okay, so there are also some other people who are good resources to reach out to, and we will go through some of those. So let's see. Okay, so there are family justice counselors. I'm not sure if anyone has mentioned them in other sessions, but they are government workers. So they provide free services. They can provide general information and education. They provide limited mediation services. So some of them can help with mediating between parties, and they can provide emotional support and short-term counseling. They can provide parenting assessments and reports. So for example, a views of the child report. A views of a child report is when a family justice counselor or any other expert speaks to a child and then summarizes their views in a report that can be used, for example, in your court proceedings or to show, or when you're assessing parenting time to sort of give the child a voice. And they can also refer you to other community services. So the family justice counselors are available throughout BC. They can provide services virtually, and they work in justice access centers and family justice centers. So these are, so they typically provide free services, and they're really helpful when you need someone to bounce ideas off of and when you need legal help. So then we're going to talk about parenting coordinators. So parenting coordinators are for people who have a parenting agreement or an order. So the idea is that this is a child-centered dispute resolution process that's outside the courtroom. So it's for things that are more day-to-day. So for example, extracurricular activities, where your children should attend school, and some very minor parenting time issues. So for example, Christmas, what time should we exchange the child and that kind of thing. So they can make determinations when the parties are unable to come to an agreement, but they cannot change guardianship, legal or physical custody from one parent to the other. They cannot substantially change the parenting plan. They cannot significantly modify parenting or contact time with a child. They cannot change primary residence of a child. They cannot modify child support obligations. They cannot affect division of family property or debts, so they cannot make any determinations of that. They cannot provide legal advice. So their role is more of a mediator who can help with day-to-day issues so that you don't have to go into court for every little thing. So now that we've talked about the people who can help, what processes are available, we'll go through something about recording your agreement. So, okay, you have a settlement, now what do you do? So first of all, let's talk about separation agreements. So it is a legally binding contract. There are interim agreements versus final agreements. So interim agreements are things that you get into before you have a final resolution of your matter. So like I said, for example, if you have an urgent parenting issue, you might get into an interim agreement for now about the parenting issue while you're waiting for a final determination or agreement where you can sort out all the issues. So I wanted to take everyone through this guide on how to draft your own separation agreement. I'm gonna try switching my I'm gonna try sharing my screen.
While you do that, so we're at around 6:16 and you're almost done your slides. Do you want to keep going?
If everyone's okay with it, we're almost done. So maybe we can keep going and then I can let everyone go so that everyone can have a nice evening
All
if
right,
everyone's
so
okay with that.
thumbs up if you want to power through. right.
Okay,
Okay.
seems
Perfect. Okay. So I'll let you take over. So while you're situating yourself with the guide.
okay. Okay, can everyone see it?
Yep.
Okay. So the reason why I wanted to show everyone the guide is because this is such a great resource, and really I think everyone should take a look at this. So we go into here. So they have every section separated out. So you can go into any section you want, but for today's sort of demonstration, we'll just go through it one section at a time. So here are the instructions on how to use it. If you intend on making one yourself, I recommend you go through this in detail. But for now, let's just, I just wanted to show you how it works. So you can plug in your name, your address, and postal code, and you can pick which clauses you want to include. So you can put in your marriage date, you can put in your marriage location, and if you don't want the clause, you'll just click don't include. So you'll put in everything. If you don't have children, then if you have children, then you'll, exclude this clause. So whatever you don't need to use, you'll just don't include it. So then if you look at all of this, at the end, we will see conclusion. And then here, you can open a text version, which essentially generates what you've put into the agreement. So if I go back to section 1 and I put in a name, let's say ABC, address Vancouver, and then at the end, I open a text version, you'll see that it automatically populates the information. So this is a great resource for you when you want to create a separation agreement. Of course, you can't just rely on the text, and you should review it and make edits to suit your own situation, but it is a great resource to check out. And here they also have formatting instructions, and they teach you how to step-by-step format a separation agreement, which is extremely helpful. And here they have a sample agreement that you can take a look at and hammer out your own if this is what you want to do. So I highly recommend this resource. I've put the link in my slides, and I think if you're looking to do a separation agreement, you should definitely check this out. And okay, so we're gonna go back to our slides. So I hope everyone can see my slides. Okay. So the next thing we'll talk about is final orders or consent orders. So would be, for example, if you have already started a court action and you're in the middle of it, this is your best way of doing it, because then you can file the final order and essentially have everything done. So the form is Form 18 consent order. So another thing I wanted to show everyone is what we call the pick list. So I am again going to swap over to my other screen. If you can give me a second. Okay, so we're back here. This is the provincial court pick list. So when we call it a pick list, it means it has sample template clauses of what you can put into a consent order or any court order when you're asking for it. So maybe in other sessions you would have gone through it, but I would still like to show you because it's such a great resource. So for example, we go to guardianship. They have samples of how you should phrase certain clauses and phrase orders. So this is really great when you already know what you're looking for and then you just want to know what the proper wording is. And it's also good because it shows the sections of the Family Law Act that applies. So you can cross-reference it and make sure you know what your legal basis is and to draft it properly. So this is the provincial court pick list. And you can tell because in the index it says application about a family law matter. So I'm also going to show you the Supreme Court pick list. I understand that this course is mostly for provincial court, but when you're looking at wording, it's always good to look at multiple resources and piece together what fits you the best. So you'll see that here, for example, they also have samples on guardianship, for example, and they have the wording specifically for orders. So the Supreme Court pick list and the Provincial Court pick list are really great resources on how you can draft your own final order or consent order. So this really tells us, how the wording is like and what you should include in such an order. So those are some things that I wanted everyone to make note of. I'm going to go back to the slides. Okay. So the minutes of settlement, I didn't put much information here because it's not really used. It's not as common as the consent order and the separation agreement. It's mostly sort of a written record of how a court proceeding was resolved. So let's say you went to mediation, then you would have a minutes of settlement where you say, oh, on this day, we attended mediation and came to the following agreement. So it's very similar to a separation agreement, but it's under a different name. So it's rarely used when you're not going through mediation, but it's something that I think you should understand. When you see the document, you'll recognize that, oh, it is something that records the settlement. Okay, so finally, as I mentioned, there are a lot of free low-cost options out there that can give independent legal advice. A lot of lawyers out there offer unbundled legal services, which means that they can help you with certain parts of your family law matter. So for example, if you come to an agreement, they can just take a look and give you an opinion, and it would be a lot cheaper than getting a lawyer to draft or negotiate an agreement from scratch. So this might not be for everyone, and but I still encourage everyone to get a lawyer to go through your agreement or order to make sure that the meaning and effect is what you intended it to be, to make sure that the obligations are set out clearly, to think about potentially missed terms. We had from my experience, we had a case where they used a template separation agreement. There's a clause that waives spousal support, but then there's another clause that says when nothing in this agreement prevents the other party from enforcing spousal support, child support, and property division against the party's estate if they pass away. So it's like, okay, if they're alive, you can't get spousal, but then if they die, you can go after their estate. So there are some things like that that's always good to get someone else to read it over to make sure there's no discrepancies like that. So fairness as well is that when someone drafts an agreement, at first glance it might look fair, but then when you think about it, it might be like, okay, but then I gave up this, then I should probably get something in return. So it's always good to get a lawyer to go over the agreement and see how fair it is and how well it is drafted. So, and when you don't get independent legal advice or the other party doesn't, it's very important to get a waiver of independent legal advice. So make them sign something that confirms that they waive legal advice, just to make sure everything is in line and no disputes arise in the future. That sort of takes me to this slide where it's the reason why it's important to get independent legal advice is to avoid the risk of the agreement getting set aside if there's a dispute in the future. So sometimes people say, well, I didn't get legal advice. I didn't know what I was signing. So it's always good to prevent that possibility, right? So a lawyer can only give advice to one party. They can't act for both. So what happens is when you get independent legal advice, at the end, there will be a certificate that says, oh, this person, lawyer, gave legal advice to this party, and they sign a certificate to confirm that that has happened. And like I said, if you don't get that, it's very important to include a waiver, which says the opposite. This person waives the chance to get independent legal advice, and they confirm that they had a chance to, but they didn't. So I've included a link on Family Law Legal Aid, which talks more about legal advice and independent legal advice and how that all works. So if that's something that interests you, I recommend that you go check out the link. Okay, so now that you have your agreement, what do you do next? So here, you can file your agreement in provincial court, and the court form is Form 26. So it's called Request to File an Agreement. So typically you need to file your agreement when you want to enforce it or set it aside. So to enforce it means, okay, let's say, you agree to child support, someone doesn't pay, then you might want to go back to court and say, hey, we agreed to this. You should stick to it, and you might want to apply for enforcement. And then on the other hand, you might apply to set aside an agreement. So for example, you realize you agreed to some sort of income determination, but things have changed. Someone retired, someone lost their job, then you might want to file your agreement to set it aside and make some changes. So the court form to do that is Request to File an Agreement, Form 26. So court is always an option at the end, and even after you get an agreement. So as I mentioned, if there's a material change in circumstances that makes your old agreement unusable, or it makes it void, then you should go back to court and ask for a change, or you can go enforce it when someone doesn't comply with it. So going back to court is always an option when things don't work out. So it's very important that that's still on the table. So, okay, that's the end of my slide. I invite everyone to ask questions, and I hope that gives everyone an idea of what options are out there and what resources are out there as well.
Great. Thank you so much, Kahe. And whipping through that within an hour. Actually, I did have a question. So the two pick lists that you showed, can you use, so like the Supreme Court one, can you use those clauses in provincial court? And if like you have a Supreme Court case, can you use can you use the
From the
provincial court
provincial
one for
court?
Supreme, like interchange the two?
So yes, you can actually use them interchangeably. If you go back to the pick list, one of the main differences is that the Supreme Court one has Divorce Act clauses, because only the Supreme Court can do divorces. So it is very similar, the wording, and you can actually go through. You can actually go through and use either in agreement. So it's kind of interchangeable.
Okay. And that yeah, the legal aid separation agreement template. So yeah, I personally I did not, you know what, after you had shown the final version, I actually have seen some clients use it. I think it is a very helpful one because it does show on the legal aid website, the like how to do each clause. It has detailed information about those clauses and instructions, which I think is very helpful. I know that there's some other types of resources out there. And I have seen them come through to, like, I know at my firm, and they're not really that helpful. The way they term things is, it's kind of like, it's definitely not a one size, shoe fits all type situation. So I do appreciate the legal aid one, because legal aid is the website is a very valuable resource. I know I use it myself. especially because it helps explain things in, plain language because, even for myself, and I'm not a trained lawyer, but I've been in the industry for quite some time, but sometimes I'm like, I don't understand the way they're saying this. And so I do find the legal aid website is very, very helpful. And same with the other resource you shared, Settlement Smarts, a national self-represented litigants project website, has a lot of valuable resources, which I find are so helpful. And it does help simplify and explain things. But yeah, no, thank you so much. And it was funny, last year we had a presentation and it was about research, and the presenter again whipped through her same thing within an hour. And she said that the best type of presentation is the one where there's no questions because everyone's thinking, like they're just absorbing, right?
Well,
So
hopefully, everyone has gotten something from today's presentation. So I did get a question under my DMs. So someone asked, so if an established separation agreement becomes difficult to comply with when circumstances change, can a new separation agreement be created? So yes, the parties can always come to the table and do an amended agreement or an updated agreement. You can always come back to the table and discuss. I hope that kind of answers your question. You don't have to go to court when there's an update. If the other person is like, okay, let's do an amended agreement, that's totally fine. You can 100% create a new separation agreement.
I think it's always better if you can do it outside of court because you can get it done a lot quicker than going to court. If anyone has, especially in provincial court, you don't get to pick what days you can go in. They tell you, and sometimes you can get in pretty quick, and other times you can be waiting like over a month. So yeah, anytime that the two parties can come to an agreement between the two of them themselves and then make changes where they have to, I think that's always better.
100%. And it's always easier to sort of talk out of court because when you go into court, things get messy and people get emotional. So if you can resolve it out of court, that's most likely the best. Okay, and someone asked if parties have parental agreement filed in court, what court process would be needed for passport and travel disagreements? Getting passport issued for a child and which parent gets to keep the passport and allowing travel. So I hate giving this lawyer answer, but it really depends. It depends on what the agreement says. It depends on what the parental agreement really sets out the responsibilities. So very broadly speaking, both parties need to agree to get a passport issued. That's most likely what it is. So I'm not 100% sure how to answer this question. If the question is whether you can file it in court to enforce it, then definitely you can file the parental agreement in court, bring a court application, and then have a judge decide. But otherwise, I've shared the sort of methods you can deal with that today, and I'm not sure if Jennifer has something to add to that answer.
Yeah, I think it's more of like it's a very case by case unique situation. I mean, obviously, if you can get the two of you to discuss travel passports between the two of you, it's always better. And then you can create a new type of agreement. I don't know if this is actually even touching on the question itself, but like if the two of you can come to an agreement for travel, let's say travel outside of Canada, there is a free government form. It's a travel consent letter that both parents can sign to make travel easier. And for passports, again, if the two of you can come to an agreement, I feel like you can make a separate agreement or change your agreement to add those new terms in, because you can, to my knowledge, and correct me if I'm wrong, you can update agreements as often as you need to when things change, as long as the two of you can agree.
Yes, so you can always come back to discuss. So, the person asking this question says passport and travel issues are not in agreement because there was no agreement. So so correct me if I understand it correctly. The question is, if the parties come to a parental agreement and they agree on, who gets the passport and who keeps it, then sort of what happens and how do you make sure that happens? I don't know if that I'm understanding the question correctly, but so typically, your agreement should set out the process of how, for example, how many days notice the other person should have for travel, how, who gets to keep the passport, how many days, whether they can deny or whether, sometimes you might have a clause that says, oh, the party shouldn't unreasonably deny travel or that kind of thing. So if you built in the process in the agreement, then it would be easier to sort out when there's a dispute. So it really depends on how you draft the agreement and what is included and what everyone can live with and how flexible you are with the other person. It's very hard for me to kind of say what the court process would be. The basic court process would be to file it in court, ask for an enforcement, bring an application, but it really depends on what's in the agreement. So some people do, they put an addendum or a schedule in the agreement and say, when someone wants to travel, when someone wants to travel, they will fill out this travel authorization for the other person to sign. The other person will sign within however many days. That could be something you can consider when you build an agreement. I hope that kind of answers your question. I'm not sure if that's what you really mean. And another person also says, is there any pick list for civil law or law library? I believe that there is a pick list for civil law, but I am not 100% sure.
Yeah, unfortunately, this is only focused on family law, so we won't have any of those resources for a pick list for anything outside of family law. I think it might just have to be a simple Google search, civil, Supreme Court civil or provincial court civil pick list. Yeah, but yeah, so anything, questions should be family law related only, provincial court family law related only. Yeah, I think everyone, I'm not, I'm actually not seeing any of the questions tonight.
The question seems to be coming directly to me, and I think I've got everyone.
Okay.
And, just some, concluding remarks, I guess, this is the last session. I guess I just knew that this is the last session. I think, settling out of court is something that is usually better for everyone, and it's less adversarial. There's so many resources out there to build an agreement and to sort of go through what you should consider. So, strongly recommend trying to settle out of court and reading through those resources because they're so great. Like the agreement generator, it's such a great resource. It has all the clauses pre-built in. It's always good to go check that out.
Hey. All right, so we can give a couple more minutes, otherwise we can wrap up early tonight. And again, thank you so much. I think it's just really helpful just to know, like, knowledge is power. So even if things don't personally apply to you, it's always helpful to know all the options out there, especially when it comes to if you're for especially any participants tonight who are in a family law case and the other party does have a lawyer representing them, learning different types of settlement options or just even terminology. So when you hear those terms coming at you, at least you have a full understanding of what they mean, and you can automatically know, okay, well, if opposing counsel is like, oh, let's try four-way meeting, or we should do some type of collaborative type agreement or sort of collaborative process. At least you know what those terms are, and then right away you can be like, nope, that's not an option for me. And so you have those tools already. Okay, so if nobody has any other questions, I'm going to stop the recording and I think we can end. All right. Okay, I'm going to stop the recording now.
Yeah, and thank you everyone for coming.